You're listening to the Immigration Lawyers Toolbox Podcast, the podcast that keeps your practice sharp and your clients happy. I'm your host, immigration lawyer John Khosravi, and every week we're bringing you insights, tips, and real-world conversations with top immigration attorneys and industry leaders. Whether you're here to grow your practice, stay on top of the latest trends, or get inspired, you're in the right place. Ready? Let's go. Hello, fellow Toolboxers. Welcome to episode number 388 of the Immigration Lawyers Toolbox Podcast. It's something I haven't done in many years, but I'm publicly recapping AAO decisions I read, particularly here in the EB-1A extraordinary ability field for February, again, 2025 of AAO decisions, and recapping what I've learned from them, what you can learn from them, what to watch out for, all intended as general education on individual legal guidance, obviously. But there's a ton of cases here, a ton of gold, just there's no nuggets. It's going to help you become better at this practice. This is was going to be, for our private circle.so community page or for our new course. But in line with the fact that I've launched the EB-1A Extraordinary Ability course with the 01 seminar add-on, I thought, I'll publicly do this so everyone gets to know what kind of analysis, kind of thought process I have in the EB-1A, maybe just make it a regular podcast episode because I know a lot of people are interested in this stuff and not everyone could go behind the community page and all that kind of stuff. So I thought I'd share it to help practitioners know what's going on. It's chock full of a lot of info. So either if you're an expert in EB-1A, it's something to listen to, saves you the hassle of having to read it all yourself. If you're mid at it or you're new, it's like everyone who even thinking about doing EB-1A could listen to this and definitely should just listen to the car before you're taking a nap or something on your headphones on and just fall asleep to it and then replay it. Whatever you get, it's really important stuff and it's just done for you. So I think you enjoy it a lot. I'm taking a page out of Kevin Gregg's book and analyzing it. It's a lot of work through this stuff. Read it, write it, all this kind of stuff. But you're going to really enjoy it. So please take a listen. And if you're interested in learning about EB-1A, how to do it, we have the course for you. It's in our Circle.so community. It's a paid premium course. But email me at info@immigrationlawyerstoolbox.com to join. Or if you're already a member of Circle.so, just go to your EB-1A tab on the left side, click on it, and it'll have the information for signing up, getting access to this video course and the 01 seminar add-on that comes with it. I do want to thank our sponsor, Serenade. They're a group that you all heard of already, e-immigration by Serenade, and hot off the presses, they've now integrated with visalaw.ai, where 10,000 users can now connect their e-immigration accounts to visalaw.ai, allowing them to generate expert letters, court documents, petition briefs, and entire case packets directly within their case management system. Its case management means modern drafting, so you can build stronger cases faster than ever. The combination of e-immigration and visalaw.ai means what used to take hours can now be done in minutes. Just think how much faster your immigration workflows can be. Learn more at get.eimmigration.com/visalaw.ai. So that's a really crazy partnership that they got there. I can't believe that came together, but it did, in the sense that it's such a powerful group to be. And I'm going to be publishing this pretty soon, but I did an interview with the founders of both companies. Now I was in Denver. We got a camera crew and everything. So it's a real, short tidbit there. You're going to be hearing pretty soon from them. But it's amazing when the two powerhouses get together, what they can do. And it's going to be a big game changer in what we do here. I want to also thank Serenade because they've been a sponsor for the magazine. The Immigration Lawyers Toolbox magazine, episode 9 or issue 9 is already out. Issue 10 should be coming out pretty soon. If you're interested in getting published in immigration law, you want to share your knowledge to a group and to get known the group and all that kind of stuff, just help bring up everybody. To please email me a topic that you know well. Write a 2 or 3 page topic. Go to the website, immigrationlawyerstoolbox.com. Go to the magazine link, see what kind of articles are there so you get an idea what we're looking for. And just email me a topic. I'll see if we've done it before. If it's interesting, we'll work on creating an outline or some bullets of how it's going to be organized, and we'll write it out 2 or 3 pages. I think you could do it, and you could really get known within the community by doing this. So please let me know. Having said that, none of the information here is intended as individual legal guidance. Please consult with an immigration attorney, but you all know that already. Let's get it started. So the first case I want to go over is from February 3rd, one of the first case that published for AAO decisions. And it was particularly interesting because it 2 points. One is they had the minimum 3 criteria accepted, even though the applicant sent all 7. They said we have not all 7, but 7 out of 10 we have. But they accepted 3, but they denied him on the final merits determination because their analysis of sustained interest is that it's going to continue the claim once they're in the United States. And one of the main problems they found was the fact that they're involved in the cannabis industry. And that's something that's for years been popping up, and it's not clear how strict they're going to be on it. And here they touched upon it as a major reason or a main reason why they didn't prove the case, but they didn't go into the legality of it, admissibility issues of it. So let me talk a little bit more background on it. This is for a software developer and entrepreneur, but having said, they quickly say the job title is the CEO. So again, it's EB-1A, it's a self-petition. And the person creates a software platform for the cannabis industry. So immediately they're going to a federally illegal area. And they've had previous H-1Bs, and they're probably working on H-1B in the status. So that becomes an issue right there. How was the H-1B approved either at the embassy or with change of status in the United States, the extensions, because they had several H-1Bs since 2008. Maybe this software happened afterwards. I don't know, but that's a problem right there. That wasn't caught. Now they got they don't go into how they got this, but they got the participation of judge of others, authorship of scholarly articles, and leading or critical roles. So that's how they handled the three. They also had two previously EB2 petitions approved, and they probably because of they're probably Indian, I'm guessing, so because of the delays, they're trying to get EB-1A to just get the visa both concurrent. I don't know. They don't say it exactly, but that's probably what's happening. Now they had two textbooks they wrote that sold 5,900 copies. But the AAO said that the petitioner did not provide comparative data to show how the sales figures rank, not only within one independent publishing company, but within the broader field as a whole. So they couldn't get that one just to help establish them. And then they get into the sale of the proposed acquisition of the company, which is supposed to be for high dollar amount, and saying that qualifies under international recognized prizes or awards. But this sale never went through, and so it's kind of a hollow thing to mention. And they go into that and spend some time talking about that. And there's some other parts too, but that just shows like they got the three merits, but when they go into substantial prospective benefit, the director determined that the petitioner has not established that his entry would substantially prospectively benefit the United States because a core function of his business is to support the cannabis industry, and cannabis remains a federally prohibited controlled substance. The director concluded that the petitioner had not established that his employment would not contravene federal law. The director also made the broader determination, aside from the cannabis laws, that the petitioner did not provide either details, facts, or opinions which address exactly how the petitioner's work will provide a benefit to the U.S. prospectively. So that kind of analysis has to go through of how the prospective analysis happened. I'm not sure, is that Khosravi analysis? Khosravi analysis, that's not exactly Khosravi analysis. Khosravi analysis is like in totality, are they able to like be this level? The sustained claim, I think, is a prospective benefit. It's a separate criteria. I think the statute separates out. Let me double check that really quick. Where's the pause button on this? So I'm reviewing my outline, my trustee outline for my EB-1A course. And when you look at INA 203B1A, it goes into three prongs that primarily the Immigration Nationality Act, which is always the short version of what the rules are, then the CFR really gets into it. But the alien has extraordinability. That's the first prong that they could prove. That would be the 10 criteria in the Khosravi analysis. And then the subcategory 2, the alien seeks to enter the U.S. to continue work in this area of extraordinability. And 3, the alien's entry into the United States will substantially benefit prospectively the United States. So it's INA 203B1A, Roman numeral 3. That's not usually one that people get denied on. Usually it's, the missing criteria or Khosravi analysis, which is the first one. The second prong of are they going to continue work in the area, I've seen that be problematic when the people are going through consular processing and at the interview they say like, oh, my expertise is this, but I'm going to go to the United States and go do something else. And that's when it's like, it hits number 2 and number 3 because how is it substantially going to benefit prospectively, I guess. But that's one you don't see often, but this cannabis situation was a major issue in explaining it. That's what they thought. I'm surprised they didn't go into more detail to create problems for them on this one. But that was an interesting case I wanted to make sure to go through. That's the first February 3rd case from the AAO decisions. The next case is February 3rd, it's the third AAO decision of the month. And I'm not going to go too much into it, but it's a great primer for those getting involved in immigration because they argue, for 7 of the criteria. They get published material in leading or critical role, but they knock out a bunch of other ones. So it's a good primer on issues that exist and how they can knock them out. For membership and a lot of the stuff that they argue, they're saying that they didn't heavily relied on letters from associates and stuff, nothing independent or objective. So that made it difficult for them to even get into it. For membership, judging of organization, doing internal kind of judging is not something that's a big deal. Original contributions, that's always a tricky one. And then they also go into scholarly articles, but I just want to go over the high salary part. They say that the petitioner submitted a letter indicating that the beneficiary earned a monthly gross salary of 25,000 lari, plus 2 bonuses that are collectively worth about 6 months' salary. The former employer asserted that the petitioner's net monthly salary after payroll tax was at least 5 times higher than the average monthly salary of a project manager in Georgia. Petitioner did not submit evidentiary evidence to establish the average monthly salary of the project manager in Georgia. And so as you see, like you have to have some sort of corroboration to go into it. It doesn't necessarily say if this amount would, if it was 5 times, it would be good or not, but you have to have some standards of how you could compare it. That comes really hard, especially a country like Georgia, a smaller country, to get some document analysis or statistical analysis. I'm not sure what they would necessarily want for that. That's what always become problematic when you do salary analysis because they want that kind of stuff in there. The next case is case number 4, which I'm going to go over briefly. It's for a biomedical researcher, and this is another case where they argued everything, and the government goes and knocks down most of them, so it's a good primer. But the 2 points I specifically want to make, and I see this a lot because when clients contact me to say, hey, I have patents, I got grants, and that goes, grants especially will go far for the NIW kind of field because it shows that they're involved in the field. But patents and grants on their own are not awards per se for EB-1A. The director explained here, research grants are not awards for excellence, rather they simply fund research or work. The director also acknowledged that the record establishes the intellectual property agency of Armenia granted the petitioner a particular patent. However, the director observed that patents do not meet the plain language requirements of this criterion, which contemplates prizes or awards for excellence in the field of endeavor. Moreover, the director noted that even if a research grant or a patent qualified as a type of prizes or awards for excellence contemplated by the criterion in 8 CFR 204.5, the record does not establish that either the grant or the patent commanded a substantial level of recognition that could indicate the prizes or awards are nationally or internationally recognized. So that's one that goes in. So again, you have a lot of people contacting you about, hey, I got this patent, I got this grant. It's like, okay, that may be a big deal, rarely, but it's not the best. And the second note I want to make on this one is about having articles written about you. They essentially have their name mentioned in a 10-page article, and they're like, this is not enough. They say the 10-page research article mentioned the petitioner's last name one time in the context of the first named author of a particular research study that provides one of several possible mechanisms. Only 2 sentences in the 10-page literature review address the petitioner's research study, and one of those 2 sentences equivocates on how explanatory the petitioner's research may be for the phenomenon in question, before immediately moving on to discuss another highly possible mechanism. This contradicts the petitioner's characterization that the research article deems her work is authoritative, quote unquote. Moreover, the citation to the petitioner's research is one of 75 citations throughout the entire 2022 research article. Now, I'm not saying don't mention like these patents and awards and article mentions like that because it helps with the Khosravi analysis, but this is going to be weak. You got to really have 3 strong ones that really take you there. When you're in the science fields like this, the judging usually is easier to get. Authorship of scholarly articles is usually easy to get because they're scientists, researchers. They're doing both those. They're judging other people's work and articles, and authorship of scholars, and reviewing and publishing their own articles. So they quickly grab those 2 for EB-1A. But the third one becomes really important in the totality of the situation because so many of these scientists do capture these 2 minimum. How are they going to really push to show themselves different from the pack to be able to get this EB-1A standard? For the 5th and 6th cases for February that were published, I'm going to go briefly through them because this one is the 5th case is for a lawyer and legal entrepreneur. Essentially, they got everything denied, so it was a weak case. So I'm not going to go through it, but I just want to reference that lawyers are doing this. But the next one's only a 2-pager. It's very short. It's for an architect and urban designer. The director initially at USCIS approved 2 of the criteria, but then denied it. On appeal, they were successful, actually, the petitioner was, in adding a 3rd one that they satisfied the high salary criterion, and they said the record includes a petitioner's 2021 income tax form and compensation data for architects and urban planners indicating she had received significantly higher remuneration, which I can never pronounce, relative to others in the field. Unfortunately, they don't go into the details of what documents they used to show the people in the field what country it was and what they considered high relative to the salary. So that was annoying because it's a short one. And then the second annoying thing about it is this is something AAO for the last many years have been doing is they don't make the final Khosravi analysis decision on their own. Here they remand it and they say now that we did 3, it goes back to USCIS for them to do another review. The director's decision is withdrawn. The matter is remanded for the entry of a new decision consistent with the foregoing analysis. What's annoying about that is USCIS could take 6-8 months to come back with it, and they might come back with the notice of intent to deny anyways and say, oh, we found problems with this. And then what do? You go to AAO again. That's why AAO decisions is good for studying for me, but like you really got to go down the path of filing a lawsuit on these kind of things. because USCIS to just keep going the circle of pushing back, and you have to appeal again or sue or that kind of stuff. And they could still say you got the 3 criteria, but we don't accept you for Khosravi analysis. Then what do you do there? I don't think that's like a discretionary thing. I don't even know if you could sue on that. I think I've seen cases where judges say we're going to leave it up to USCIS because it's discretionary. So that's really becomes problematic when you have a closed case like this. But it was interesting that they put there. The petitioner here argued commercial success criterion for comparable evidence. They didn't really get it. Again, it's a short 2-pager, so we don't have information of what happened or what their analysis was or what they argued. But it's good to see this kind of stuff happens. These remands or these fixes of criteria on the AAO level do happen. Cases, I want to briefly just go into them. Case number 8 from February 7th is for a pianist, a piano player. And for that one, the AAO does mention that they attempt to use post-filing evidence, such as this Bloom Tampa Bay article, to establish eligibility, which is not permitted. So bringing in new evidence, you got sometimes those let it in, or at least it has some impact on them, but it's not something to use. And then case number 9 is for a salsa dancer choreographer instructor. I did a separate AAO decision. It was free for a period of time in the circle.so page, but now it's part of the EB-1A seminar is added to there, where I go over 3 dance instructors, salsa dancers in general, from December 2024, January 2025, and February 25. This is the 3rd one. And it goes into these analysis of how they view dancers, what articles, what criteria they can argue, and how to back it up. So that could be something that's very helpful for viewers and people analyzing these cases. The next case is for a tennis player. It's a 10th case from February, and I had 2 interesting points in it. First off, it's not part of the interesting points, but they got the lesser awards and published material, which usually for a top athlete is pretty easy because the athletes are competing, so they do win awards, and they have articles written about them. So they knock those out, but then they try to get the 3rd one with membership in associations or leading or critical role. And so when we go into membership associations, they go into the fact that their petitioner claimed that the director failed to follow USCIS policy, knowing that the election to a national all-star or Olympic team might serve as comparable evidence for evidence of memberships. So in the memberships analysis, they use a qualifying national expert in the field on road, but they didn't really buy it or affirm it. And what is important here, I make this argument a lot for my sports players that if they're part of the national team, their memberships and top organizations. And a lot of times we don't get a decision on it because it just gets approved. So it's like they don't, even if it's not accepted, they don't get into it. But here they're saying, okay, we're going to use comparable evidence to get this one in. And they're saying the 6 USCIS policy manual F2B1 comparable evidence. She also cites a 2023 non-precedent decision bar stating, given the level of accomplishment required to secure a place on a country's national team, which competes at an international level, it appears reasonable to conclude that it is the functional equivalent of an associate of the type contemplated in the association. So it's, I guess they're arguing membership, but at the same time, they're saying comparable. USCIS policy, however, did not require the director to accept the petitioner's membership on the blank national tennis team as comparable evidence of her membership in a qualifying association. The policy states only that election to a national all-star team might serve, quote unquote, might serve as a comparable evidence. Also, our non-precedent decision does not bind us in this manner. And then they go here. Further, USCIS considers comparable evidence only if a regulatory criterion does not readily apply to the petitioner's occupation. So that's petitioner's occupation is really important there. The petitioner has not demonstrated or even asserted that the membership criterion does not readily apply to tennis players. See Guido B. Miller, number 20 CV 01471LB 2021, Westlaw 5 or WL 568850, North California, February 2021. Affirming USI's decision that before the agency can consider comparable evidence, a petitioning formal national team coach had to demonstrate that the criterion of 8 CFR 204.5832 did not apply to his occupation. So that's for the comparable evidence aspect. If you're going to argue it, you got to knock it out of any of the 10 criteria to be able to get into that one. So that was really an important pickup from this one, because sometimes you just shoot out the comparable evidence, but you got to make sure it doesn't fall to the other one. I thought was important enough to mention here. All right, I'm going to stop it really quick and just let you know, what you're learning here is just nuggets, but the true gold is in the EB-1A extraordinary course that we have along with the O1 seminar combo. You can purchase it, and it's a really reasonable price for a practice area that's going to be 6-7 figures. So if you want to join our Circle Out So group, our community page is free. It has dozens of hours of CLEs and training and all that kind of stuff, white label documents, samples of my marketing that have white labels so you can put your information on it, handouts that we use at our firm that you can put your firm, all this kind of stuff is there. And then if you want to take the next level, purchase this premium course and get your firm up and running and your teams up and running on it. That's the EB-1A Extraordinary Ability course. So if you want to join and you're not part of Circle S already, email me info@immigrationlawyerstoolbox.com and let me know your name and bar info so I know you're an attorney. Add you to the course page, add to the community page, and we get you all started right there. Now back to the show. It is for International Supply Chain Specialist. And so that's an interesting one. You're like, well, is that going to work on this? And almost got it. So it got a published material, judging the work of authors, and authorship of scholarly articles. So it met the third criterion, but then the AAO goes and just knocks the wind out of all of them. So even though you got them, they're not good enough for this International Supply Chain Specialist. So they say that for the articles, for example, they presented 2 notable articles that covered her and discussed her work. Nonetheless, the remaining pieces in the records were not about the petitioner specifically, but articles on her area of employment in which she contributed opinions or information on the respective articles' topics. I guess maybe you could do that. That should have been argued as a published material, like written by her or something like that, or interviews about her, rather than, I guess that is considered one. I was going to say like maybe she say she published scholarly articles in that sense, but she didn't publish herself. I guess, I don't know. The article about the petitioner, without more, do not demonstrate that such press coverage is consistent with sustained national claim. And then this footnote here, which we can get into later, is she included several pieces of evidence in the RFE, including her 2023 award, and her book originated after filing the petition. So that leaves it open, like maybe this stuff was positive, that extra stuff she provided after filing, but she couldn't use it here. So maybe in this case, refiling would have been better than appealing for the AAO. That potentially may have been the argument I would make if in the denial decision they said that this stuff's good, but it's after filing, so we can't include that. The petitioner provided evidence that she served as a judge for the 2023 awards. So there's that judging one that they downplayed again and say it's not big, it's just one. We accepted it as criteria, but it's not good enough. And then they presented a letter that says advisory opinion does not sufficiently detail its reason and conclusion. This advisory opinion was for original contributions. It claims that the petitioner has an effective algorithm for transactions and an exclusive methodology for verification of customs values. It does not explain further what those are or how they make the program a significant contribution as claimed. So one thing that happens is when they don't want to do stuff, especially when it comes to letters, original contribution, that's so discretionary that they're just weaken it out and they knock it out. Then they say, next we turn to evidence submitted to show if the petitioner has earned a high salary or other significantly high remuneration consistent with this restricted visa classification. The petitioner presented a letter from her company stating her proposed salary, which is kind of weird. What, your proposed salary? The petitioner did not supply evidence of what salary she has received. So it's kind of weird, the prospective salary that she hasn't actually got paid. She should have got one and should have paid stuff for it. The petitioner also submitted an expert opinion from Dr. Blank, an assistant professor of entrepreneurship and small business at Blank. As noted above, we may use opinion statements submitted by a petitioner as advisory, but will reject an opinion or give it less weight if it is not in accordance with other information in the record or if it is in any way questionable. Here, Dr. Blank considers several pieces of evidence in his analysis, such as the petitioner's book and her award, that originated after the time of filing. So they got this letter that included this because that documentation of her background was after the fact, the awards in the book. They can't get this letter in. So this would have been one you probably should refile because there's good new stuff in there, especially an award. You knock out that category, that could get it there. I mean, could the AAO just say whatever, approve it? Yeah, I've seen them do that kind of stuff, but that just goes to how strict or restricted they want to be. There's a footnote here I haven't read. It says, we observe that some of the documentation the petitioner submitted regarding her salary, such as a 2023 bank record, and documentation the average salary of supply chain experts originated after the filing of the petition, as noted above. So, yeah, there's so much stuff after filing that happened that potentially just refiling the case would have been better for this one. I'm surprised they got 3, but I mean, who knows? If you refiled them, you might not even get those first 3 because they were pretty skeptical of it here. The 12th EB-1A AAO decision is for, it's a mouthful, a senior member technical staff information security engineer. And these kind of positions, always, I mentioned earlier, they got the judging the work of others and authorship of scholarly articles. Those are easy. Not easy, but those are ones they typically get. I'm really going to just focus on the high salary portion that's here. Now, they say the petitioner provided new evidence on appeal, so they couldn't accept it. But then they go into this, and it really highlights how hard this category is because you got to find specifically comparable data. The petitioner argues his eligibility for his criteria based on his salary as a senior member technical staff information security engineer. So I'm not sure if it was a good idea to make the job title so niche. I mean, I like narrowing it down, but I mean, that's the mouthful. I don't know if I do that.
As evidence comparing his salary in relation to others in the field, the petitioner submitted screenshots from salary.com. That's a weak thing to do, including the salaries and positions for level IV, I think it's Roman numeral 4 or 6, probably 4, information security analyst. So they're comparing that mouthful title that they have with information security analyst. In addition, the petitioner offered letters from JC and KG opining that the petitioner earns among the top level for a level 5 information security analyst. Oh, that's failure right there. Apples and oranges. However, the petitioner did not provide the proper comparable salary information for his particular occupation. Again, the petitioner is a senior member technical staff information security engineer rather than a level 5 information security analyst. Further, the petitioner did not demonstrate that a senior member technical staff information security engineer is comparable to a level 5 information security analyst. In fact, the petitioner's position as a senior member technical staff information security engineer suggests a higher job classification than a level 5 information security analyst. While they may share many skills, experience, education, sometimes even projects, there are some key differences between a security engineer and a security analyst. And so they go, so that's, again, you got to be, this is fine tuning. You can't be just throwing this stuff out there. They really get you on how you label things and label the job title and the comparable evidence. That's why the high remuneration, it seems people, it's one of those, I talked about earlier, people contact you about patents. They say, I have a patent. I was like, well, it doesn't matter. And then when they say high salary, that's always one I take with a grain of salt too, because it's hard to get comparable evidence and to really document it. Case number 13, quick note on February 13th, is for a senior security engineer. For awards, they had argued a Red Bull sponsored hackathon was what they were providing. They didn't accept that. And then membership in the senior IEE membership failed to show outstanding achievement judgment of experts. So that's all the typical membership thing. So I want to briefly mention that. We're skipping number 14 for voice actor, but going to case 15 from February 18th. It's a geoscientist volcanology researcher that was denied but sustained on appeal. And they got 5 different criterion. So it's a really interesting case to read for AAO to fix things up. I'll read a little bit of it. For example, she performed critical roles for blank, the distinguished reputation of which is supported in the record by its recognition from the Carnegie Classification of Institutes of Higher Education for its highly respected research activity. This is for leading critical roles, which holds a highly regarded position with the QS World University Ranking. So that's good. It's a short one, 6 pages for something that they're fixing everything up. And then for original scientific contribution, it says the petitioner's pivotal contribution to the project cannot be overstated. It was her meticulous research. Essentially, she figured out this top volcano stuff and no one else knows. So it was a pretty solid case for EB-1A, but the USCIS knocked it down. It should have been approved, and they got 5 of them, got approved, sustained. So that's a great work right there. This is the 19th case for February 25th, and it's a short one I'm going to mention. Is for a competitive swimmer. And the person actually got 4 of the criteria accepted: lesser rewards, membership associations, published material, and leading a critical role. I wish there was more analysis of what the leading critical role was, but the issue was with the final merit determination, Khosravi. And what's interesting here is, let me highlight it. I thought I highlighted earlier. Is they come back and say, on appeal, the petitioner asserts that the director intentionally disregarded his receipt of a bronze medal in the U.S. Open Swimming Championships. He stated that this is a major international award establishes extraordinary ability in the Olympic sport of swimming. He describes the U.S. Open as one of the preeminent international swimming competitions. He states that his bronze medal at this event reflects his high level of expertise. A small blah blah. As the petitioner argues, the director's decision does not discuss the petitioner's bronze medal, so AO agrees. Contrary to the petitioner's allegation, the record lacks evidence that the oversight was intentional. Okay. But the record appears to identify the U.S. Championship as a major swimming competition open to athletes from around the world, the kind the director faulted the petitioner for reportedly not meddling in. So, okay, I didn't read it, I guess. Whether it's intentional or not, you prove it, but this is the kind of frustration you get with USCI's cases. So they remanded. Hopefully gets approved on this one. They got a remand. So it says the director's decision is withdrawn. The matter is remanded for entry of new decision. Who knows which way that's going to go, but that was an interesting thing right there. They just disregarded really strong evidence, which happens a lot. So you got to tell your clients about this in the initial consultation. Like, you might be the best, but it depends on what they actually want to read. Okay, the next case, number 20, is February 26, 2025. Speed skating coach. This is interesting because it seems like USCIS completely messed up this one. And the AAO, instead of just reviewing it, just remands it, which is another obnoxious kind of thing. Well, first of all, they accepted one criteria, which is membership in elite coaching associations for the speed skating coach. But that's all they say. They don't get into how they proved it, which I wish they did, because I like learning about what arguments they made for associations. But then they go into like the different things that are argued, and they say that, for example, let me start here. In denying the petition, and you can use the laws here, the director again discussed the petitioner's claims of eligibility only under criteria number 1 and 8, so they didn't really analyze it. The director incorrectly stated that the petitioner was a financial risk specialist who intended to carry out research and development, and referenced incorrect dates of the RFE and the petitioner's response, without providing an analysis of the evidence in support of the other claimed criteria or comparable evidence in the record. The director concluded that the petitioner had not established eligibility. So there's massive errors in the process going on there. And then they say, after reviewing the record in its totality, we conclude that the director's unfavorable determination did not specifically address all the petitioner's claims or evidence, and in some instances did not appear to adhere to USCIS regulations and policy guidance in explaining the reasons for denial. The case law I want to mention here is very helpful to your analysis. It says an officer's written decision must fully explain the specific reasons for denying a visa petition. See 8 CFR 103.3A1 Roman numeral I. Absent such an explanation, a petitioner does not provide a fair opportunity to contest the decision. See e.g. matter of M-P-20 INN December 786 BIA 1994. So when they come back at you with an RFE or denial and they don't explain it, this is a citation, both the regulations and a court case that you can use, so that you could challenge them what it is. But when it goes to the criteria, AAO says the director did not fully, for example, on the awards, the director did not include a full analysis of the evidence submitted under his criteria and awards, including whether comparable evidence could be accepted and examined. On remand, they should look into it. When it comes to published materials, same thing. They didn't analyze it. This includes copies of articles about, the petitioner submitted a large volume of evidence in support of this criteria with the initial filing in response to the RFE. This includes copies of articles about him and evidence of the various publications. However, the director did not discuss or analyze any of this information, so remand, go look at it. And then evidence of original contribution. For example, this one I want to mention, a person who is an Olympic coach whose athlete wins an Olympic medal while under the person's principal tutelage would likely constitute evidence comparable to that of 8 CFR 204 H35. USCIS policy manual at F2B1. On remand, the director should evaluate this. So if you are going to do a coach in using their athletes' like success, you could get that in under this. Again, it's 8 CFR section 204.5 H35 Roman numeral 5, and then references 6 USCIS policy manual at F2B1. So that's a thing there. But again, they remanded again. Same thing for leading a critical role. Remand to revalue. It's just kind of annoying. They didn't really get into themselves. They just said do it, which means this person is just waiting in limbo forever. Who knows if he can maintain their status for adjustment of status, what's going on with consular processing. They may all of a sudden get subject to travel ban. So these delays do a huge factor on everything. For case number 21, February 26, 2025, it's for a business administrator. I just quickly want to note that the USCIS gave them one criteria, which is publishing. They were published, and then the AAO took it away. They said that the director concluded without further comment that the petitioner has satisfied this criteria, published material about the alien. As explained below, we disagree. And this is some citations and analysis on what you just hear. The published material should be about the person, relating to the person's work in the field. See Noruzi v. Napolitano, 905 F sub 2D 535 2012, holding that the articles about the Iranian table tennis team, which only briefly mentioned the person, were not about him. See also Negro-Plumpe v. Okin 2008 WL 106997512 D Nevada 2008. It says, concluding that articles focusing on a character played by the person or the show he performed in were not about the person. And then published material that includes only a brief citation or passing reference to the person's work is not about the person. And then it follows up, however, upon review of these reports, and so the petitioner submitted numerous media reports pertaining to logistics and supply chain management for beverages in China. And it says, however, upon review of these reports, many of which were duplicate reports featured in multiple sources, it appears that the submitted materials are primarily about the Chinese beverage industry and the role the petitioner employs in the industry. While we acknowledge that the reports contain information about his employer's advances in the field, and that some of the submitted reports include his photograph and a short quote from him, the submitted documentation does not discuss the merits of the petitioner's work, his standing in the field, any significant impact his work has on the field, or any information so as to be considered published material about the petitioner as required by his criteria. It's for a developer of semiconductors and related technology. It was an Indian gentleman, and they got participation as judge of others and authorship of scholarly work, so citations and probably reviewing other citations. So again, the scientist field you can knock out two pretty quickly, but then they go to they're trying to get the third one, which is original contributions, which is some interesting stuff here. They say the petitioner submitted 13 letters from experts in electronic packaging and semiconductor thermal management fields and proof of the beneficiary's authorship or co-authorship of 14 published articles in the field since 2019. The company also submitted evidence that he has reviewed peers' articles in the field of professional journalism. They say the company submitted. I think they did an EB-1B through the company, which I don't like people doing that. I like self-submitting. But okay. The director found that the beneficiary's articles reflect original contributions in the field. Okay, that's good. But the director concluded that the evidence insufficiently demonstrates the purported major significance of his contribution. That's what becomes so hard about this, because you got to be able to explain some complex stuff. First of all, it has to be real original contribution and major significance, but explaining that's hard. So first they say number of citations. They provided a printout showing he had 170 citations, which looks good, especially for NIWs. That would have been good. But then it says the director found that the website showed that others in the electronic packaging field had each written more than 450 published articles, generating more than 11,000 citations. Not sure exactly what that means. There's a footnote that says, also, an expert who provided a letter in support of his petition stated that he has authored more than 300 published articles in the field. So this guy only did how many? He has 170 citations. How many articles was there? 13 articles, letters, 14 published articles in co-authorship. So he didn't do much compared, I guess. They look at that. I'm not sure how USA is, if it's true or not what they're saying. But on appeal, the petitioner, because there's so much analysis and comparison, I haven't done the research, but I'm always hesitant on these kind of things. On appeal, the petitioner submits evidence of other researchers who say have had major significance on the field and have generated fewer citations than a beneficiary. Before the decision's issuance, however, the director sent a request for evidence inviting the company, it should be the person, to submit objective evidence that the beneficiary's publications have garnered a significant number of citations. The company has not claimed or demonstrated that its additional evidence was unavailable at the time of the RFE's issuance. We therefore decline to consider the new evidence on appeal. So that's kind of annoying. And then it goes into the expert opinion letters. We agree with the petitioner that the director undervalued expert opinion letters that the company submitted. In her decision, the director discounted the letter because the beneficiary solicited them in support of his petition. That's not fair. The director stated that the beneficiary's original contributions in the field must be demonstrated by pre-existing, independent, and corroborating evidence. I'm not sure that's a standard. As the petitioner argues, however, there's no blanket rule that solicited expert letters warrant less evidentiary weight than pre-existing evidence. USCIS policy states, quote, detailed letters from experts in the field explain the nature and significance of the person's contributions, may also provide valuable context for evaluating the claimed original contribution of major significance, particularly when the record includes documentation corroborating the claim's significance. See 6 U.S. Policy Manual, USCIS Policy Manual F2B1. Criteria 5. See also Rubin v. Miller. The USCIS decision letter does not reasonably explain why evidence in existence prior to the preparation of the petition carries more weight than new material, specifically opinion letters. But the AAO says, even affording the expert opinion letters the full evidentiary weight due to them, they do not sufficiently establish the claimed major significance of beneficiary contribution. Now, they go in, I'm not going to read it, or maybe I'll read some of it, but they go into analyzing the letters and be like, and it's like technical stuff. I have no idea what they're saying. But okay, let me just read it. For example, a letter from a professor emerita of technology and economics at Hungarian University touts the importance of beneficiaries' research on thermal management of electronics, stating, quote, this area has been crucial for reviewing and studying electronics for lifetime reliability and energy consumptions for critical data centers that feed next-generation computerized and AI, electrical engineering, and research technologies. Her letter also states the beneficiaries' work to investigate the impact of energy immersion cooling is required for advancing the benefit of data centers that are the repositories for AI technology, unquote. But the letter does not explain how the beneficiary's specific research had advanced the fields, whether any electronic devices or other data centers have successfully implemented his ideas, or whether his work unlocked doors to others' important application or studies in the field. I guess after reading out loud, I understand it better. But that just shows these getting letters, they're full of holes. It's so hard to get a good opinion letter written about this, because you got to be mindful of so many different factors in there, what they're saying, and the person who's writing it has to agree to, sign it, And then similarly, a fellow emeritus of U.S. Technology company praised the beneficiary's research on the impact of aging mechanical properties of thermally conductive gap fillers. His letter states the beneficiary's finding helps in predicting the lifespan and performing of the materials, which is vital for maintaining the integrity and efficiency of electronic devices over time, unquote. This letter also states that, quote, his work has helped to improve electronic packaging and semiconductor thermal management, unquote. But like the previous letter, this letter does not explain how the beneficiary's specific research has advanced the field and provide examples of applications that have been successfully adopted his idea. So it's just important to know, for reading this, if you're going to get these letters, you got to do the above. So that's it. I'm gonna hopefully have show notes on this somehow. Again, this is probably gonna be temporary, open to public, but some show notes so you can more easily find this. My sister's gonna have her work cut out for her, but to get more quickly trying to review these. But the AO decisions are there, so it's really good to review these. You become really your expertise in this area just goes dramatically when you spend time reading these, and hopefully I saved you the trouble and the time of having to do it yourself.
All right. Well, that was a long one right there. Studying all these cases takes a while. I was prepping the NIW one, and there's just so many NIW denials and AO decisions in the last year and a half, because I think people are crazy and start submitting it all because they were getting approved, and now they're all getting denied. Essentially, not all, but there's so many NIW denials. And I'm going through it to find nuggets of information there. It's hard to find because it's a lot of the NIWs are just like, a person's a cab driver trying to. I'm being facetious here, but it's hard to pull it out. But the EB-1A, it's got information and guidance and the law and how it works, all this kind of stuff as you saw here. There's just so much to learn. And every month when I read it, it's always new. It's never like the same stuff over again somehow. And always refresh this. Whenever I start a new EB-1A case, I read these and it just gives me confidence. When someone contacts me and has a consultation session, when I read this and I think about the course and the criteria and all this kind of stuff, it resettles me of like what I'm going to do here. Plus, all this information I read here, we're going back in time now, the AO decisions, and getting synopsis of all the courses. But I get it nowadays. You read all of the court cases, AO decisions, but now I have AI review all of them. Then, based on the AI synopsis, I pick and choose which ones I'm going to read, which is it took something else 10 hours, brought down to 3 hours. But that's how powerful it is. But those synopses are there. So if someone's going to hire you or you get a consult and you know what kind of job title they are, you go on the website and quickly learn. We have a one pager that's just a list of jobs that are in this EB-1A. And you can try to look for the last couple of months, find the job title that matches what you're looking for, read the case, find which case it is, read that case to see if like any tidbits information you get from there so the consultation come better, what kind of words are in this field, what kind of denials they're seeing, what kind of memberships are good, all this kind of stuff would be really helpful. And just to really knock it out of the park and sell it and close that lead and really be prepared to create a strong case by using past experience and past evidence that it's not necessarily your personal experience, but from your knowledge of reading these kind of cases or being aware of it. So it's a magical thing to do, and I'm glad to provide it. Again, that's free. Just join our Circle That SO page, and then purchase the premium course, and get your life started, get your practice going, and take things to the next level. Until next one, have a good one. If you like this episode, follow us on Instagram. Our handle is Immigration Lawyers Toolbox, where we post the latest statistics, tips, and more. And stay tuned for more from the Immigration Lawyers Toolbox podcast.